ECIR is just for internal records inside the Enforcement Directorate. They don't have to give it to the accused. Under Section 17, the ED has search and seizure powers. This has continued to be allowed if the officer has enough reason. So that's another important part of that act that the Supreme Court has upheld today. Section 24 of the act says the burden of proof lies with the accused. Now, this is important because in most crimes, it is up to the prosecution to prove that that crime has been committed. But there are exceptions to that rule, and that includes for PMLA, where the accused will have to prove their innocence first. Section 45 is a very important part as well. It talks about the twin conditions of bail under the Act, and these have been upheld by the Supreme Court. So the twin conditions are that if a case under the ED goes to court, the public prosecutor gets to argue first, to hear his or her side of the story first, and bail can be granted only if the court is convinced the offence will not be repeated or committed again. Section 5, attachment of property. The Supreme Court has upheld this power as well, saying it's necessary to investigate proceeds of crime. So what this essentially means is it gives sanction to the ED's ability to arrest first and probe later. It can be seen in the current context as a setback for opposition leaders questioning ED cases against them. It compels the Enforcement Directorate to at least communicate grounds of arrest later on. So you can just tell the person why they're being arrested or why they're being detained, but you don't have to hand them an official document. And you can just tell them the broad grounds of arrest. The reasoning behind this that the Supreme Court has given in its judgment is that if you tell the accused exactly why they're being arrested, it could tip them off and allow them to destroy proof. The burden of proof, again, continues to remain with the accused. But one other important point that the Supreme Court has said, that vacancies in the PMLA Appellate Tribunals, that's the final court that you can go to if you think that you've been accused wrongly, those have to be filled up. There are supposed to be 5 spots, only 1 is filled up right now. So the court does say that fill up those spots as early as possible. Now, we have to look at this order in the context of what is happening right now, which is why let me just bring up those visuals again that we played in the beginning of the show. Because at least a dozen opposition leaders are being probed by the ED in various cases. Sonia Gandhi, of course, that's a story that's making the headlines. She's being probed in the National Herald newspaper case, the charges of money laundering. Same with Rahul Gandhi, her son, and Congress leader, again being charged for money laundering in the National Herald case. Karti Chidambaram is being charged for a 2011 accusation of taking bribes for giving out visas, of facilitating visas, and the charges that illegal payments were made to issue visa. P. Chidambaram, Congress leader and former Union Minister, is also being investigated right now in the INX Media and Aircel Maxis case. Again, the charge is money laundering. Shiv Sena leader Anil Parab is being charged, is being investigated in the Ratnagiri resort construction case. The charge is money laundering. Sanjay Raut, Shiv Sena leader, is being investigated in the redevelopment project case. Ajit Pawar, NCP leader, is being investigated in the cooperative bank scam. Farooq Abdullah, National Conference leader, being investigated in a J&K Cricket Association charge scam, and the charges embezzlement of funds. TMC leader Abhishek Banerjee, he's the nephew of Mamata Banerjee, is being investigated in the Bengal coal scam. The charge again is money laundering. The list really goes on. DK Shivakumar from the Congress is being investigated in a disproportionate assets case. The charge is that there was embezzlement of funds. So all of these are ongoing cases, but we should look at also what is the track record or the success rate of the Enforcement Directorate so far. And these figures were revealed in Parliament just yesterday, in fact. So over the last 17 years that the PMLA has existed, 5,422 cases have been registered. Charge sheets have been filed only in 992 cases, and convictions secured are only in 23. Proceeds attached are over 1 crore plus. So the question to be asked today is, are there enough checks and balances today in the system to ensure there is no misuse of the Enforcement Directorate's special powers? To speak on this, I'm joined first by Karnal Singh, the former director of the ED. I will be also speaking with Sanjay Hegde, senior advocate, and Satya Pal Jain, senior advocate. Welcome to all of you. Mr. Singh, let me begin by just getting your take on some of what the Supreme Court has said. And I think we should start with some context of why the Enforcement Directorate gets these special powers. Why does the Supreme Court say that the officers of the Enforcement Directorate are not like regular police officers? Can you contextualize that for us first?
The police officers, they come under the Police Act. And the Police Act says anybody who has been enrolled as a police officer is a police officer. Now the dispute is about whether it is the person has the power to arrest should be a police officer, or the person who has been enrolled as a police officer is a police officer. So Supreme Court in this particular case can come out with a decision that the Enforcement Directorate officers may be coming from any source, maybe coming from the police, maybe coming from the Income Tax Department or Revenue Department. They are not considered to be police officers. That is a judgment of the Honorable Supreme Court.
I understand that, sir, but my question was actually to try and explain to our viewers, why have these special powers been given to the Enforcement Directorate? What is so special about this particular investigative agency that they don't have to tell the accused why they're being arrested? They don't have to offer up an ECIR. Why so?
See, number one is the PMLA Act has been enforced or come into enacted by the Government of India and the legislature on the basis of international commitments. There have been the money laundering has immense impact on the economy, on the society, and on the countries. And therefore, in 1989, there was under the United Nations, there was a meeting, and on the basis of that meeting, it was decided that initially it was a drug case only, and in those drug cases, the people should not be allowed to use fruits of the crime. With the passage of time, they included more cases than organized crime. And after 9/11, they also included in this the terror financing cases. Now, internationally, they are finding it that the money laundering cases are impacting the countries, impacting the nations, and therefore FATF has started monitoring what are the legislation one has made and how effective are you implementing it. According to that, India also came out with the Prevention of Money Laundering Act, which came into force in 2005. And therefore, the special powers have been given to the Enforcement Directorate because that's the only agency which investigates money laundering cases to attach the proceeds of crime and also to investigate the criminal offense against them. So actually, this has two sides. One is the civil side where the properties are forfeited and then finally confiscated. And the other is the criminal side where case is taken to the court. And for investigation of that money laundering cases, they have to be given power to search, seizure, arrest, and to prosecute in the case.
Just one more question, sir. Right now, the big charge by all of the opposition leaders, and I read out 12 names, there are obviously many more, is that the Enforcement Directorate is being used as a political tool. Do you agree with that?
See, these are allegations and counter-allegations. And if anybody has an allegation against it, there's a court. And one can go to the court, to the lower court, to the high court, or to the Supreme Court, get the redressal. And therefore, I'll not be able to comment on political issues. I'll be able to comment on what is the legal provisions and how those legal provisions are being applied.
No, I understand this, sir. But simply, the reason I'm asking is that they point out that a lot of the cases filed happen to be only against opposition leaders. On the other hand, we've had conviction figures come in which are really dismal. Why is the ED not being able to convict or finally taking it to its logical conclusion? Hence the charge of the ED being used as a tool of oppression.
See, you have to understand what is conviction. See, the process is you investigate the case and file in the court, and then trial takes place. And you must be aware that trial in our country, it is not in the hand of the prosecution agency. there are various factors, and there is a long trial in our country. When you say conviction rate, there is a misconception. And misconception is that you take the number of cases charge sheeted in the court and number of cases convicted. That is not the conviction rate. Conviction rate is based on the number of cases decided. Now, the conviction rate of it is very high. The number of cases decided are basically around 24. Out of that, 23 have been convicted. So you have to understand that conviction rate means what? Many people are just taking conviction rate as number of cases decided divided by the number of cases prosecuted. That is not the definition of conviction rate.
Thank you so much, Mr. Singh, for joining us first and putting that into perspective. Sanjay Hegde, Satya Pal Jain are with us now on the show. Sanjay Hegde, ED gets special powers because of the way financial crimes are looked at, the larger ramifications they have, and the Supreme Court talks about it. It can fuel and fund terrorism, etc. That is why this leeway, where the burden of proof is on the accused, more stringent conditions of bail. Your take on what the Supreme Court has said today, and do you think it empowers the ED further?
Before we go further, let me explain to you and the audience how exactly the term money laundering came about. See, during the 1920s, when there was prohibition in America, the mafia made a lot of money out of prohibition-related activities. They had to show it legitimately. How do you show it? You showed it by way of a business, which obviously took money in cash. So they established laundries and took money in cash, and then they showed it as their business income. That's how the term money laundering comes in. Now, money laundering being in the modern context, as Mr. Karnail Singh pointed out, was also seen in legitimizing drug money or money from terrorism. So the UN Convention was only with regard to specific offenses. So that is what the original term of scheduled offenses was. Now in this country, what you have done is you have expanded every kind of offense and added into the Money Laundering Act. Somebody has been corrupt. It's a local thing. You say, okay, if he buys a house or two, and then if somebody else buys that house from him, that person who's bought this house, knowing nothing of the provenance of the house, that house is also liable to be attached. We have essentially made a harsh law, stretched it out greatly, and we are administering it selectively. So there are several clauses of the law which are quite disturbing. The law says that you will not get bail unless you qualify for the double test. That is, you are that you will not that you are prima facie not guilty of the offense, and secondly that you will not commit it again. These kind of tests are very difficult to grant bail. So essentially what you have done is that you have empowered officers who work under the finance ministry to come after every citizen's life. And while you speak of all these political ones, I am not concerned. Let the politicians kill each other. Let the politicians go after each other. They will create a lot of work for lawyers. What I'm really concerned for is the ordinary citizen who will get caught in all this. And the Supreme Court empowering it, this harsh law, even when similar sections have been on bail, etc., or on confessions, have been struck down, even in drug cases. In drug cases, statements made to the drug enforcement officers are held to be not admissible. Whereas under this act,
right,
an ED officer can just say, come on, tell me what you have to say, and he can use that against you. So a lot of harsh provisions have today been sanctified by the Supreme Court.
They've been upheld. They've been upheld by the Supreme Court.
They have been upheld as constitutional by the Supreme Court. I do think that this is probably dangerous for democracy. There have been judgments of the Supreme Court, such widely framed judgments of the Supreme Court even earlier, which the Supreme Court at a later stage has re-looked at and relooked at the wisdom of the judgments and said, no, that is wrong. You may remember that in 1970s...
Right. 1 minute. I'll come back to you, Sanjay.
Yeah.
Let's keep the conversation flowing. Satya Pal Jain, thank you for your patience. You've listened to all of the views. I want to get your response to what Sanjay Hegde said, and I think that is the crux of the matter. We've gone through the legalese, we've tried to explain to our viewers what it's all about, the context of the opposition parties. He says it's not about opposition parties. It's about the ordinary citizens, because no law is for one class of citizens, right? It is extremely stringent. Do you think there are enough checks and balances as of today to ensure that there is no misuse?
I have to make two submissions to the observation made by earlier panelists. Let's not forget, Supreme Court has not done anything new today. Supreme Court has not vested any power in any officer. Supreme Court has not added even a single comma, bindi, or a word to the act. This is an act which was enacted by the Parliament of India in 2005. Supreme Court has only upheld the validity that yes, it is a valid law, it should be continued, and there is no question of challenge to the law.
Right.
So therefore, as per the Constitution of India, the power to make laws vests with the Parliament. And it is the Parliament which enacted the law. Number two, when this law was enacted, it was those people who are now in opposition at the center who were in power at that time. It was their time when this act was enacted. So they were aware of all these provisions and the use, misuse, abuse of the law, etc., etc., etc. Third thing that I'm saying is this: the power to interpret law is given to the Supreme Court, which it has done. It may not be to our liking. I may not be able to appreciate the judgment from my own angle and say, no, no, this should have been like that and that should have been like this. Let's not forget, the judgment is perfectly within constitutional parameters. The law was enacted by the competent authority, which is the Constitution gives the power to enact. Supreme Court has been given the power to examine. It has been examined, and the executive is implementing that. So far as the question of, my friend was saying earlier also, the number of opposition leaders are being charged more, or the ruling party leaders are less in number. See, where is the question of that? Somebody may be opposition in the center, may be in power in a particular state.
No, he said he doesn't care about opposition leaders. He's saying what about the ordinary citizen who doesn't have the clout of opposition leaders? Where is the check and balance, sir?
I'm asking him a question. I have got the copy of the Supreme Court order today. Okay? There are 240 petitions which were challenging the law. And I'll request Mr. Hegde to just go through the list of the petitioners as well as the very, very senior lawyers who appeared for them. And I don't want to discuss it further. A common citizen can dare even to engage the type of senior lawyers who were appearing for the petitioners in these cases. All those accused or who are accused of money laundering are very, very big people. You are showing the pictures on the screen. I don't want to name anybody. These are big people. These are the crimes, heinous crime against the society. They are the white collar.
No, but sir, my question is still not answered, Mr. Jain. What is the check and balance? Whether they're big people, small people, a law is not made for big or small people. Law is made for any citizen who flouts the law. My question is, where is the check and balance? Do you think there is sufficient check and balance in the system as is?
Checks and balances, sufficient checks and balances. Let's take the example of attachment of the property. First, when the property is attached, the attachment order is passed by the concerned officer. It goes to the adjudicating authority for confirmation. And if the adjudicating authority doesn't confirm the order goes, property gets released. And if the order is confirmed, then the appeal goes to the Appellate Tribunal, which consists of the retired judges of the High Court. And against the order of the Appellate Tribunal, the matter goes to the High Court. What more sufficient issues that you want?
Sir, may I point out what has been said about vacancies in the Appellate Tribunal? May I point out, sir? What has been said about vacancies in the Appellate Tribunal? They need 5 people, there's only 1.
Because of the reason that the issue of the validity of the rules which were framed to make appointment of the judges, etc., has been pending in the Supreme Court for a very long time. Number 2, these members are appointed not only by the executive. There is a representative of the Supreme Court also. There is a panel which selects. So simply because the vacancy is there, if we go by that issue, 1/5 of the vacancies in the High Courts are vacant. So meaning thereby that all the High Courts become redundant. There are
Okay,
many
Sanjay
vacancies
Hegde,
which
your
lie in the
counter.
Supreme Court.
Just
So
because there's a
Supreme Court becomes
vacancy
redundant.
doesn't mean you have to make the law simpler
Yes.
or you have
There
to
must be
ease the
a-
burden.
I'm in favor of that.
No,
Government is
Okay,
making laws
let
possible
him
and
respond, sir.
take
Let
forward.
him respond, and let's keep the to and fro quick and lucid so all the points can come in. Yes, Mr. Hegde.
It is the ministry's responsibility to make the appointments, and they haven't been made from 2019. So today, if there is an order, you've been showing that 20 crores seized from somebody. Now, supposing without knowing it, you had bought a flat from the lady. Yeah, just a year before that. Now, an ED officer said that, look, this is the proceeds of crime. I am attaching it. You want to go and challenge it before a tribunal? The tribunal doesn't exist.
No tribunal, Mr. Hegde, just stop here.
Yeah, you are adjudicating all.
Just a minute.
Please, I didn't interrupt you.
1 minute, sir.
I didn't interrupt you.
1 minute, sir. 1 minute, sir. Let
From
Mr.
the-
Hegde finish his point,
From
Mr.
one
Jain, and then I'll
officer
come to you. One by one, please. As it is, it's a complex, legally filled subject. I want my viewers to be able to understand what's happening because, like we said, this is not only about powerful politicians. This is rule of the law. Tomorrow, any politician or any XYZ will be charged under these laws. Are there enough checks and balances still in the system is the question we're asking. Mr. Hegde, please complete your point quickly and then we'll
Yes,
get Mr. Jain to respond. Yes.
So from one officer, you go to another officer. Normally within the department, you get no relief. You are supposed to go to a tribunal. Tribunal, there is nobody who's appointed. Thereafter, you go to the High Court. In the meanwhile, your property is stuck up. You may have loans from the banks. All kinds of complications arise. And till the matter is finally decided in trial, nothing can happen. Also, the officer decides that you're acting a bit too smart, then he decides, okay, fine, we might as well arrest you. I don't have to give you reasons. I don't have to give you the ECIR. Then let the judge see whether you satisfy the double test. And then if you get bail, so be it. What it essentially does is forget the big fish, forget all the directors, etc. of the ED. It effectively says that ministerial officials within the finance ministry can, if they want to make your life miserable and create a kind of police state atmosphere, they can do it.
Okay. Allow Mr. Jain to respond. If someone is out to get you, they can. That's the question. Whether you deserve it or not is something that the court will decide. I'm talking about the intent of the accusing or the investigative officers.
I'm really surprised at the replies which have been given by my very, very respectful and learned senior counsel. See, you are disputing the wisdom of the parliament to enact the law. You are disputing the wisdom of the Supreme Court also, which is interpreting the law. And you say, no. Parliament is wrong, Supreme Court is wrong. I am right. So do whatever I want it to be done. Number one. Number two, so far as the attachment part is concerned, Mr. Hegde, go through section 5 of the PMLA once again, section 8 once again. If you want to attach a property, the concerned officer has to pass an order giving the reasons why it is being attached. This attachment order goes to the adjudicating authority, which if doesn't confirm the attachment within 6 months, the attachment order goes. After the adjudicating authority, then the appeal goes to the tribunal. After the tribunal, which is a forum consisting of the judicial officer, the appeal goes to the High Court. 4 checks, you go the Armed Forces Tribunal Act, you go the Central Administrative Tribunal Act, income tax, sale tax, customs, all acts put together, there the procedure almost is the same. One authority to another to so and so. And if you feel it's not proper, go to the parliament. What is the law? Law is the law enacted by the Parliament of India. Law is the law upheld the validity by the Supreme Court of India. And still you feel that no. Whatever I'm saying is the only correct proposition of law.
Just quick counter from that, Mr. Hegde. Quick counter from that, Mr. Hegde. Yes.
The quick counter is that I have never accused Parliament of having wisdom. Mr. Jain basically says that, if you don't like the lawmakers come in into Parliament. Mr. Jain, my respectful answer is we made parliamentarians to make reasonable laws under the Constitution for us. We did not make parliamentarians who would impose emperors upon us. That is what you have. You you have directorate of this, directorate of that, and everybody is supposed to be subordinate to it. Essentially, the enforcement directorate becomes a mechanism to selectively choose targets if they are big fish, or if they are small fish, you are caught in the crossfire, so be it. And that is the wisdom
Sanjay
of
Hegde,
Parliament.
the problem is, one minute. Can I also give a counter? See, this is what happens when you have two seasoned senior lawyers on the show. The anchor has to say nothing. 1 minute, sir. Let me also ask. Let me ask, with not the kind of legal knowledge you have, but on behalf of the viewers who are trying to make sense of it, Mr. Hegde. So what you're essentially saying is, because this law is possibly open to misuse, should it be watered down? The premise of the PMLA, PMLA, Mr. Hegde, was always that these are heinous crimes. These are crimes that are difficult to track. They're difficult to join the dots. Hence, all of these special powers were given.
That is why I gave you the background, right? Prohibition, that kind of money. So when the UN got in the charter, it went after drug money. It went after arms money. Today, anything and everything is being dragged into the PMLA as a scheduled offence. Supposing somebody has not properly complied with the company law. Supposing somebody has been a corrupt person. There is the Prevention of Corruption Act, but no. Let's drag him through the PMLA, because we can attach his assets, we can render his or her living difficult, and we can threaten arrest at any point of time. And the burden of proof will also be upon the fellow. Show me that you are not corrupt. That's like asking, have you stopped beating your wife? That's what the reverse burden of proof is.
Okay. Mr. Jain, last comment to you. Reverse burden of proof. How do you do that?
I'm really once again surprised. My friend is doubting the validity, utility of the law made by the Parliament of India, which has been upheld the validity by the Supreme Court of India. Still he says, no, I'm not doubting Parliament.
But that's all right, isn't it, in a democracy, Mr. Jain? You can question the laws that govern us in a democracy.
Tamanna, who will decide whether the law is valid or not? Who will decide whether it is harsh or not? Who will decide whether it is competent or not? Either the Parliament or the Supreme Court. Both have upheld it.
No. Let me be clear. We are not claiming to decide the law over here. We are an open forum. As the fourth pillar of democracy, we are a forum to air views, so that our viewers, potential voters, can come to the right conclusion. Okay, I have to wrap.
One line.
To be used against the people who are indulging in heinous crime.
Okay, allegedly, those crimes have to still be proven. Only 23 have been proven. Okay, 1 minute. Mr. Hegde, last line, and then I really have to wrap, sir. Yes.
Parliament made 377, said that unnatural sex was a heinous crime. The Supreme Court upheld it. Thereafter, the Supreme Court changed its mind and it struck it down. The last word has not been said.
It's a strange parallel you've drawn, Sanjay Hegde, but I will leave it at that. Engage with lawyers' arguments at your own peril. I've done that today. Thank you so much. Satya Pal Jain, Sanjay Hegde, lovely speaking with you. But while we're talking about proceeds of crime, these are all in the realm of allegation. That 15 crore rupee count, which I talked about at the beginning of the show. And then in 35 minutes, since we broke that story, it's 15 crores have become 20 crores. I'm showing you those visuals from Arpita Mukherjee's apartment. Bhavtosh with me on the phone line for the latest. Bhavtosh, where has that counting reached?
Well, it has reached more than 20 crore rupees, and what sources in the Enforcement Directorate has told us, Tamanna, that only 40% of the money that has been seized has so far been counted. 4 counting machines have been brought to the house, and the money will be counted throughout the night. Not only that, what is more shocking is that the gold ornaments that have been seized, including gold bar, is worth at least 2 crore rupees. Even that valuation is still going on. The total amount of money that has been seized is now upward 41.9 crore rupees since last Saturday. And the total amount of gold that has been seized is over 4 crore rupees. So if you count both the gold as well as cash that has been seized, is a whopping 45.2 crore rupees. And ED officers have said